I'm Drew Stevenson, and this is a lecture for my administrative law class about the Supreme Court case Johnson v. Robison from 1974. This case is about statutory preclusion of judicial review for certain agency decisions or actions. And for my students, when we talk about preclusion of judicial review, we mean that there's not going to be any judicial redress available for whatever the grievance or complaint is in this case. And our problem is that, or where we start, is that the Administrative Procedure Act has a section that creates judicial review of agency actions and creates a cause of action, but then has a couple of exceptions or exception categories. And one is that we're going to study in this case. This is the most famous U.S. Supreme Court case about this issue, is about statutory preclusion. The second one is about matters that are committed to agency discretion by law. So let's go and look at what happens in Johnson v. Robison. Again, this case is in almost every administrative law casebook. And one of the problems with this case is that I actually have to explain a little bit of backstory because there was an earlier case and then Congress tried to change the statute to make it clearer that they didn't want the court to review. So let's start with the APA. The Administrative Procedure Act in 701A says that there's no judicial review when it's either precluded by statute, that's A1, or where the agency's decision is committed to agency discretion by law, that's in 701A2. So we really have kind of two forms of preclusion. The first is explicit or specific statutory exemption from judicial review. By the way, this is relatively rare. Or a statute that commits a matter to completely to agency discretion by law. And I have a separate video about that. The big case in your casebook that illustrates that is Webster v. Doe. Okay, and also keep in mind that courts are often resistant to attempts by Congress to sweep whole categories of decisions out from under judicial review, and will sometimes resort to twisted rationales to circumvent these bars depending on what's at stake in the case. So the background of Johnson v. Robison really starts with an earlier case from the D.C. Circuit Court of Appeals in 1967, Tracy v. Gleeson, and I'm going to call this the Tracy case. And I know you may be thinking, that's not in my casebook, why do I care? It actually really matters for understanding what's going on in Johnson v. Robison. So this was the estate of a deceased veteran who sought judicial review of a Veterans Administration determination that the decedent was not entitled to disability benefits for the years 1949 to 1960. And so, by the way, both of these cases are about the Veterans Administration and veterans benefits. And at the time, the relevant statute, which is 38 U.S.C. section 211A, provided the decision of the administrator on any question of law or fact concerning a claim for benefits shall be final and conclusive, and no other official or any court of the United States shall have power or jurisdiction to review any such decision. This was supposed to be kind of a favor or nice gesture by Congress to the Veterans Administration that they could have finality in their decisions and not have to waste a lot of time litigating every time they denied someone benefits. Doesn't that look to you, when you look at that statute, like no court gets to review these decisions about benefits by the VA? Well, the DC Circuit got around this by saying the statutory bar to review, by saying that the dispute didn't really grow out of the disposition of a claim, but was rather the result of an action by the VA administrator to terminate benefits that had previously been conferred. In other words, to go back for just a second to that statute, it says the decision of an administrator on any question of law or fact concerning a claim. So the DC Circuit doesn't like that they're being prevented from reviewing this. So they say, well, this isn't really a claim, this is an action by the VA administrator to terminate benefits. And I hope you can see that this is like the height of superficial semantic differences. Okay, so Congress didn't like what the DC Circuit did. So 3 years later, in response to Tracy, Congress amended 38 U.S.C. 211A to read the decisions of the administrator of Veterans Affairs on any question of law or fact under any law administered by the Veterans Administration providing benefits for veterans and their dependents or survivors shall be final and conclusive, and no other official or any court of the United States shall have power or jurisdiction to review any such decision by an action in the nature of a mandamus or otherwise. So in other words, Congress is trying to make it really clear that no court should be reviewing anything that the Veterans Administration does about benefits. And then that sets the stage, that's the statute we have as we come into Johnson v. Robison. So in this case, a veteran who had been drafted who had been a conscientious objector. And for my students in Texas who are unfamiliar with the concept, there are a number of us who think it's wrong to kill people, or at least would really want to get through our whole lives without killing anyone, no matter what, and including in war. And so there's a number of Christian denominations, for example, that are pacifists and don't allow their members to do combat duty in the military. And so the Supreme Court had early on in our history recognized this as a valid religious belief. And so we created some statutory recognition. And there's a few different ways that you can handle this when you're drafted. Now, when you register for the Selective Service, when I registered for the Selective Service as an 18-year-old, you actually had to fill out a physical card at your local post office, and I just wrote conscientious objector across the back of it. There's nowhere to check off. But when you're drafted, there is a form you file. And one of your options is to serve in the military, but you could serve, say, as a medic, or do office work stateside, basically what we call civilian service, just not combat duty. You wouldn't carry a weapon or shoot people. And so this veteran who had been a conscientious objector and had done civilian service in the military wanted veterans expenses for veterans benefits for education expenses. Now, another statute, the military, to be honest, doesn't like conscientious objectors very much. That shouldn't surprise you. And so another statute provided that the conscientious objectors were ineligible for veterans' educational benefits. So the VA denied his application. And so, okay, so hopefully you're following me so far. Robison is the claimant and the veteran who wants the VA to pay for his school, and college or grad school, said that the statutes barring VA benefits for conscientious objectors violated the First Amendment and equal protection under the Fifth Amendment. And the VA asserted that 211A prohibits the court from ruling on the constitutionality of these other statutes and its decisions under those statutes to deny benefits. So let's get to the holding by the U.S. Supreme Court. The court opens this by saying that, wow, if Congress could just cut out judicial review of actions by the executive branch, that would create a huge problem with the constitutionality of that statute. Congress cannot undo Marbury v. Madison type review just by legislation. In other words, Congress can't just say, we don't think the court should get to review the constitutionality either of a statute or of an executive act. Then it applies a canon of judicial construction that courts should try to remedy a statute's constitutional defects either by interpretation or construction or severance rather than voiding it. In other words, we should only invalidate a statute on constitutional grounds as a last resort. So the court will either try to interpret the statute, find an interpretation that avoids the constitutional problem that would solve it, or will use what we call severance, where you only strike out that one provision and save the rest of the statute. You may remember during the Affordable Care Act litigation at the U.S. Supreme Court, they scheduled half a day for oral arguments just about whether the individual mandate provision in the Affordable Care Act could be severed out to save the rest of it if that provision was held unconstitutional. So severance and interpretation are a big deal for courts in avoiding constitutional kind of showdowns with Congress. But the court actually finds an easier way to construe the statute to allow constitutional review. The claimant's challenge to the constitutionality of other sections pertaining to conscientious objectors were really challenged to actions by Congress, not the administrator. So the prohibition in 211A did not apply. Now, if you didn't really follow this little maneuver of the court or sleight of hand, depending on your perspective, basically, remember, Robison was a conscientious objector. He did civilian service. We have 211A that says you can't review the veterans benefits administration decisions about benefits, but the reason that he was ineligible was because of an actual statute that says if you're not willing to carry a gun and shoot people when you're drafted, then we're not going to pay for your college or grad school when you get out. And so the problem here, it seemed the court decides, you know what, his challenge is really to this statute that the VA applied. So we can go ahead and review that. That's not precluded by 211A. The court admits that Congress clearly intended to preclude review on most eligibility determinations by the VA to preserve judicial economy and the efficiency of the agency, and to preserve uniformity and technical expertise in the decisions. In other words, to kind of stop judicial meddling in veterans affairs. But in this case, constitutional review is okay because it's unrelated, the court says, to these concerns of Congress. Here's a review question. We're done, but I want to see if you've been paying attention. Can Congress expressly preclude judicial review of certain agencies' decisions through a statutory enactment? A, yes, but courts may find clever ways around the preclusion. Or B, no, the APA guarantees judicial review for all agency actions. Now, hopefully you know the answer to that, and if not, I don't think you were really paying attention. You were distracted while this video was going, so you should go back and rewatch it, because that concludes our lecture about Johnson v. Robison.